All right, good morning. When I call your name, please say present or here. Raise your hand so I can acknowledge you for the docket. Marshall Flores. Marshall Flores. Jacob Frericks. Jennifer Gathright. Kelly Gathright. Brandon Lewis. Randy McElroy. Randy Lee Shane McElroy. Brittany Robinson. Bo Simmons. Bo Allen Simmons. For the record, CR 21189, Tanner Garrison Sistruk. It's represented by Mr. Ron Harden, who's filed a waiver of arraignment. Court has set that for pretrial on August 24th. Audrey Thompson. Craig Turner. It's been verified in the Kaufman County Jail. We'll recall that case in a moment. Reset that. Amethyst Wesley. Here. Brandon Donahue. Misty Rice. Leonard Williams. Zachary Bird. Lori Rush. Megan Bailey. Charles Campbell. Haley Gandy. Travis Skinner. Deshaun Whitaker. Waiver of arraignment has been filed, approved, and pretrial set August 24th. Christopher LaPoma. John Lapano. Verified in custody in Cameron County. Court will recall that case. Misty Backus. Kobe Heron. DeAnthony Darnell Smith. Joseph Couch. Christopher Neasley or Nicely. Christopher Neasley. Thank you, Mr. Knoll. Am I saying it correctly? Is it Neasley?
Nice.
Nicely. Karen Sue Burton. Ashley Olds. Oh, Miss Olds is set at 11. See that. Adrian Gutierrez. Mr. Gutierrez, does Mr. Crane know that you were out of jail? All right, so he knew you're going to be here at 9? Thank you, sir. Appreciate it. Is there anyone who's in the courtroom whose name I've not called? All right, counsel, do we have anyone that's agreed or ready? Not everybody at once. Y'all calm down. Mr. Green, calm down. Contain yourself, sir.
We'll be quick.
Okay. Is there anyone who does not have an attorney and who is intending on hiring their own attorney today? Raise your hand. I'm assuming if you do not have an attorney and that if you want a court-appointed attorney, you have already gotten up and met with my coordinator, Ms. Taberham, to request a court-appointed attorney. If you have not, you need to do so. Jennifer Gathright, if you'll come forward to the podium, please, the center podium. This is cause number CR 21-117. Ms. Gathright, I believe we had you set previously last month or a few weeks ago anyway to hire an attorney. Have you hired an attorney to represent you? Who's your attorney? And okay, and Mr. Gathright, if you'll come on up, we'll just go ahead and knock these out at the same time. This is also cause number CR 21-118. Have you financially retained Mr. Hyde? So have you already secured an appointment with his office for later this week? What day, what time? What time?
I'm not sure.
All right, Mr. and Ms. Gathright, I'm going to reset you until July 27th. That'll give you that'll give you about 2 weeks. So you should be able to meet with Mr. Hyde between that time. Deputy is going to bring you this notice of appearance and you to sign. Once you get the yellow copy, you'll be free to go. Yes, ma'am. Yes, go ahead. Come on back here and meet with the pretrial release department and they'll give you more information about that. You can come around that way. You're welcome. Thank you for bringing that up to my attention. Brittany Robinson. Mr. Robinson, this is cause number CR 18-276. I see here that there's a request by you to have the court extend your period of probation for an additional year. Why are you needing the court to extend your probation? Are you working on your community service now?
Yes.
Do you believe that if I extend this for 1 year, you believe you'll be able to do all your community service and then successfully complete your probation period?
Yes.
All right. And Ms. Robinson, has anyone threatened, forced, or pressured you to make you feel like you had to extend your period of probation?
No.
Okay. And you're asking the court to extend it 1 year?
Yes.
All right. The court will extend Miss Brittany Diane Robinson's community supervision period for an additional 1 year to now expire on October 8th, 2022. All right, Ms. Robinson, if you'll come back here with Officer Matura, then you'll be able to get a copy of that. You'll be free to go. Court call CR 21-194 and 195, State versus Craig Allen Turner, who set for arraignment today. Court has a docket note that Mr. Turner has been incarcerated and verified in the Kaufman County Jail. So we will reset that case until August 12th for arraignment. and custody status. Miss Wesley? Miss Wesley in here? No, she stepped up. Mr. Gimbel, are you ready? Okay, that's fine. No, not rushing, just making sure. Mr. Knoll, same thing, still working?
I have actually on this case, the witness is here, writing the statement out. He disposed of those who may be by dismissal. Discovery.
Okay.
But I'll have a firmer announcement here shortly.
Okay.
Easily is covered. Hopefully this afternoon, that may be.
Okay. Mr. White, are you ready on anything? Okay. Does Mr. Jeff Wood know that his client is in the Cameron County Jail, do you think? Okay, so he's not, I don't want him to drop all the way over here. Okay. Okay, and if Jeff wants to just zoom in, you know, he can do that. Because anyway, I don't want him to drive all the way over just to for an announce that we got a Cameron County Jail. Because I think that's the only one that he has all day. So, okay, thank you. Green, you ready on Miss Burton?
We are ready.
Miss Burton. This is cause number CR 2324, State versus Karen Sue Burton. Miss Burton, if you'll raise your right hand, please, I'm going to place you under oath. Miss Burton, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Miss Burton, are you a United States citizen? And do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Are you currently undergoing treatment or on medication for those disorders? Do you feel like your treatment or your medications are enabling you to have a rational understanding of the proceedings here today? No? But do you believe that the medications and the treatment are helping you helping your mind be stable to where you understand what's going on and you're not confused by your mental disorders? Okay, thank you. I know that question sometimes is a little difficult. And Ms. Burton, you're represented by your attorney, Mr. Stephen Green. Are you pleased with Mr. Green's representation of you? You feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about the paperwork that you've read and reviewed with him and signed today that you do not understand? Mr. Green, do you believe Ms. Burton to be competent?
I believe she's competent.
And you've explained to her her legal and constitutional rights?
I have.
All right, Ms. Burton, you are charged by indictment with a state jail felony offense of possession of controlled substance less than 1 gram. Is that the original charge, Mr. Green?
It is.
Okay. And the proposed plea agreement is concerns a reduction of the punishment to a Class A misdemeanor under Section 1244A of the Texas Penal Code. And so what that means is if the court follows the plea agreement in this case, the court cannot impose a sentence more than 365 days or a fine more than $4,000. You understand that range of punishment? Understanding that, Ms. Burton, the plea agreement in this case is that you plead guilty to that offense. The state recommends that you be convicted as a felon under section 1244A, that you receive 2 days confinement in the Van Zandt County Jail, that you're going to receive credit for 2 days for time that you've already served, and that you're going to be assessed a $1,500 fine, $180 restitution, $290 court costs, and a $35 reimbursement fee. Is that your understanding of the plea agreement today? And that's what you want the court to approve? All right, understanding both the range of punishment and the plea agreement, Ms. Burton, how do you plead to possession of controlled substance in penalty group 1 less than 1 gram? And Ms. Burton, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court accepts the defendant's plea of guilt. Mr. Green, any objection to states 1? States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, from the defense? All right, based on the court's review of the evidence, I do find there's sufficient evidence to convict Ms. Burton of this offense. The court will follow the plea agreement in this case. The court convicts Ms. Burton of possession of controlled substance in penalty group 1 less than 1 gram. Assesses her punishment in accordance with the plea agreement pursuant to section 1244A of the Texas Penal Code at 2 days confinement in the Van Zandt County Jail. Court orders her to pay a fine of $1,500, restitution of $180, $290 court costs, and a $35 reimbursement fee. Mr. Green, is Ms. Burton going to be able to pay anything towards her fines and costs today?
She is not here. We do have to fill it off.
All right, Ms. Burton. Once you get through in the courtroom, I'm gonna order you to go down to the end of the hall to meet with the court compliance collection officer, Ms. LaPrade, and discuss with her your arrangements that you're gonna need to undertake to pay off the things that you owe. Your failure to comply with the payment plan is gonna result in the court issuing a warrant for your arrest, okay? And I'm not just telling you, I'm gonna tell everyone in here that if you resolve your case today or any other time, and you're ordered to go down there and meet with Ms. LaPrade, when you're talking with Ms. LaPrade, you're talking with me. I'm starting to hear too many stories about people going down there and treating her poorly or having an attitude or throwing papers down or walking out of her office. You don't do that in here. You're certainly not going to do it down there. I'm not saying that you're going to do that, Ms. Burton. I'm just telling you, you were the first one up this morning. So I'm telling you, when you go down there, treat her with respect because she's an extension of this court. Okay. All right. Ms. Burton, I'm going to remand you to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward here to be fingerprinted with the deputy. After that, I suggest you get a copy of your judgment and then go meet with Ms. LaPrade. Yes, sir. Good to see you. Mr. Ashmore, let me know when you're ready. I'll get you in.
Judge, as pockets, I need to approach. There's a conflict where I need to address it.
You and your client want to approach the bench?
And with state, just need to report that I've been appointed on a custom case.
Oh, okay.
And this case was assigned to me a year ago.
Okay.
However, it's not been active until this week. And his case has been active within the last 30 days or so. So I've actually done work on this case.
Okay.
I think it'd be appropriate. I already spoke to the chamber when I got here this morning.
All right. Before we get in all that, I'll call that and we'll get her up here. Are you ready on Heron and Smith?
I just received an offer from the state yesterday on Mr. Harris, so I need to talk to him. And I don't know if Mr. Smith is out of Dallas County or Tarrant
He's here.
County.
Mr. Smith's here.
Okay, sir.
So I'll tell you what, once you talk with all your clients and you're ready on all of them, let me know and then we'll bring them all up, get them done. Lori Rush. Rush, if you'll raise your right hand and place you under oath. Ms. Rush, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right. Your name is Lori Ann Rush. Ms. Rush, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Brent Gimble. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him, have all your questions answered? Is there anything about this paperwork that you've read and signed and reviewed with your attorney today that you do not understand? Mr. Gimble, do you believe Ms. Rush to be competent today?
I believe she is, Your Honor.
Can you explain her legal and constitutional rights to her?
Yes, I have.
Ms. Rush, it appears that you have been charged by indictment with a state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram. And the proposed plea agreement in this case is that you would plead guilty to that charge in exchange for the state's recommendation that you be prosecuted convicted as a felon and punished as a misdemeanor offense at 2 days confinement in the county jail, with you receiving credit for those 2 days for time already served, but that you also pay a $1,000 fine, restitution of $180, reimbursement fees of $535, and court costs of $290. And the state would be dismissing another unfiled case. Is that your understanding of the plea agreement today? And that's what you're asking the court to approve? Ms. Rush, the range of punishment for a possession of controlled substance, penalty group 1 less than 1 gram under section 1244A is a sentence not exceeding 365 days or a fine exceeding $4,000. Understanding the plea agreement and the range of punishment, you do understand both, correct? How do you plead to this offense? Court, well, let me ask you, Ms. Rush, has anyone threatened, forced, or pressured you to plead guilty today? All right, court will accept Ms. Rush's plea of guilt. Mr. Gimble, any objection to states 1?
No objection, Your Honor.
All right, states 1 is admitted into evidence, and the court does take judicial notice of the defendant's judicial confession. Anything further from state, from the defense?
Nothing to bench, Your Honor.
All right, court's reviewed the evidence, and I do find there's enough evidence to convict Ms. Rush. The court will follow the plea agreement in this case. The court assesses her, well, convicts her as a state jail felon under section 1244A, assesses her punishment in accordance with the plea agreement at 2 days confinement in the Van Zandt County Jail. Court awards her credit for those 2 days of time served. Court orders her to pay a $1,000 fine, $180 restitution, $290 court cost, and $535 in reimbursement fees. The court finds that the state of Texas is taking into consideration unfiled F20000022, a delivery of marijuana between a 1/4 ounce and 5 pounds. Mr. Gimbel, is Ms. Rush going to be able to pay anything towards her fines and costs today?
Oh, yeah.
All right, Ms. Rush, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the bailiff. After that, I want you to report down to the end of the hallway. And if you haven't set up that payment plan, I want you to do so. And if you have, I want you to check in. And I would appreciate a payment today if you have money available. And you understand that if you fail to keep up and comply with the payment plan, the court's going to issue a warrant for your arrest. All right, go ahead and step forward here with the deputy. Mr. Gimbel, are you ready on your other clients?
Mr. Zachary Bartlett,
Mr. Byrd, CR 2148, CR 21108. Mr. Byrd is set for pretrial today.
that's correct, Your Honor. We have received all discovery and an offer, and Mr. Burke requests a jury trial,
And what's the offer that Mr. Byrd's rejected?
25 years.
And state, is Mr. Byrd enhanceable, or is that just the recommended punishment from that's the offer from the state based on the first-degree felony?
Judge of what to roughly does have warning.
Your Honor, I believe that is.
You believe it is enhanced? Well, Ms. Heisel's looking that up. So let's go ahead and clear up any confusion that we may have had, the court may have had, Mr. Byrd may have had, Mr. Gimbel may have had regarding counsel in this case. So Mr. Byrd, you stand here today with Mr. Gimbel as your attorney, and you no longer indicate that Mr. Harden is retained and representing you. Is that correct? Okay.
And Judge, I was actually incorrect. He has 2 prior enhancements, and he has 25 to life each off.
Okay. And Mr. Gimbel, you've explained to Mr. Byrd that if he rejects the offer today, that the state may not extend that offer again, and the court may not allow him to plead after today's date. And state, is that the best offer that you're going to make in this case to Mr. Byrd?
Yes, Your Honor, it is.
All right, so the court is going to place, and Mr. Gimbel, you believe that you've had sufficient time to negotiate with the state, communicate everything, strategy, offers, everything to Mr. Byrd. Because we're at pretrial now. Typically, I would set you for docket call. I don't mind setting Mr. Byrd on the jury selection docket and letting him begin that time now, but I want to make sure he doesn't forfeit anything along the way.
There is one document that Mr. Byrd has indicated to me that he's going to get finalized, that I might be able to present to the state as a copy for you.
Okay, Well, let's, out of abundance of caution, let's just go ahead and set this for a docket call and give Mr. Byrd the time to get that document or any other evidence and get everything submitted so that whenever there is a final announcement, then we know the best offer's been made, we know best counter offer's been made, and we resolve those. So are you available on August 10th or 12th, Mr. Gimbel?
August 12th will work well.
All right, so Mr. Byrd, I'm going to set you for docket call on August 12th at 9 a.m. and that will be the time at which we'll find out if we set you for jury or plea. Good morning, Mr. Wood.
Hey, Judge, I'm sorry, man.
It's okay. All right, I'm going to call Mr. Lopano's case. This is CR 2396, State versus John Anthony Lopano. Set for docket call today. I see here that Mr. Lopano is still in the Cameron County Jail. Do you have any updates for the court on when he's likely to have his business resolved there?
Judge, I don't. I've been trying to, my legal assistant's been trying to kind of be able to communicate with them and figure some things out. We've been unable to get that done at this point. So I don't have really an update as far as when that matter over there will be resolved or if it'll be resolved anytime soon. But I can try to find out and let the court know as soon as I can.
Can you remind me what kind of charge he has over there, the level?
I want to say, Judge, and I don't have the file in front of me, but I want to say that it's I think a state jail misdemeanor, if I'm not, I mean, a state jail felony, if I'm not mistaken.
So something of even charge that we have here. Do you know what the nature of the charge is?
I don't know off the top of my head.
Okay. You have a calendar available?
I've got it, Judge.
Do you know the next time that you're going to be here in August? What I'm showing is 10th, 12th, or 24th.
The 24th, is that what you said, Judge?
Yes, I have the 10th, 12th, and 24th.
Okay. Let's do the 24th, Judge. I know the 10th and the 12th, I think that's when we're going to be gone to Pittsburgh. So I think 24th will be, we should be back by then, hopefully.
Okay.
Yeah.
All right. Well, I just want to put him on a status and just so we don't lose him. So I'm going to set him for August 24th and we'll set that at 9 a.m. and
Okay. And then I'll try to find out exactly what's going on and see if we can't have a little bit more information on that particular day for sure.
All right, sir. I appreciate you. Thanks for zooming in too.
And I apologize.
You had to- Well, I didn't want you to have to drive all the way over here to announce, hey, he's in jail.
I got to come over there anytime at some point anyway. So sometimes that's my excuse, Judge. So
Hey, well, don't, your legal assistants are probably watching this, so don't let them know your tricks.
I don't know what I don't know what they're talking about.
All right, man. We appreciate it.
I see, Judge.
I see. Mr. Noel, are you ready?
I'm ready on Brandon.
Brandon J. Lewis, CR 21-175. All right, Mr. Lewis, you're set for arraignment today on a charge of driving while intoxicated with a child passenger under 15 years of age at state jail felony. You have applied for a court-appointed attorney. The court has reviewed your information and finds you to be indigent on this day. Court has appointed the Honorable Kurt Knoll to represent you. You met with Mr. Knoll today. Mr. Knoll, are you ready for arraignment?
We are, Your Honor. Mr. Lewis and I have reviewed the indictment. He has understand the charge. His name is spelled correctly for purposes of arraignment.
All right, court will enter the plea of not guilty into the record and will set Mr. Lewis for pretrial. Are you available on August 12th or 24th?
He is from out of state, but farther off, he said it, next up, discovery, June 4th.
Okay. What state does Mr. Lewis live in?
Louisiana.
Louisiana? We're at Louisiana.
And a Cocoa.
Hour on the other side of the street. So you're about 3 hours? About 4 hours to get here. Okay. Do you have a job? What do you do? Mr. Knoll, what I'm going to do is, what if we set it out a little bit further? I see it is a DWI, so I'm sure that there's going to be, you haven't received the video and those things yet, right? You haven't watched it.
I assume those is come back.
What about September 14th? Okay, so we'll set you out a little bit further. Mr. Lewis, we'll set you out to Tuesday, June 14th for pretrial. I'm sorry, September 14th.
Is there any way we can do it in the afternoon? It's a pretty long drive.
I don't want to do it in the afternoon because it bombards the jail. But that way, if you have jail clients and then it creates too much cluster out there. So we can set it, we could set it at 11. You want to do that? All right, we'll set 11 a.m. on September 14th. And so, Mr. Lewis, Mr. Knoll's going to have a appearance form for you to sign. Once you get that yellow copy, then I want you to report over here to pretrial release, and you're going to be ordered to comply with pretrial release conditions. You're going to have to make payments towards your court-appointed attorney, bond supervision, be drug tested, things of that nature. They'll give you more information about that, but you need to report to them through this door over here before you leave today. Okay. like we've come to a standstill. Mr. Sanders, you still working? You need more time?
Yes.
All right, course going to stand in recess for about 15 minutes. Brandon Donahue. All right, this is cause number CR 13435, State versus Brandon Ray Donahue. Mr. Donahue, you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Mr. Donahue, are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you? Feel like you've had enough time to discuss your case with him and have all your questions answered? Is there anything about the plea paperwork that you've reviewed and signed today with Mr. Stevens that you do not understand? Mr. Stevens, do you believe your client to be competent today?
Yes.
You've explained to him his legal and constitutional rights.
Yes, sir.
You also explained to him the advantages and disadvantages of a deferred adjudication plea. All right, Mr. Donahue, you're charged by indictment with a state jail felony offense of theft of material containing aluminum, bronze, copper, or brass less than $20,000. That carries a range of punishment if convicted of this offense and incarcerated, that your sentence could not be less than 6 months confinement in a state jail division of TDC or more than 2 years, and a fine not more than $10,000. You understand that range of punishment? If the court approves the plea agreement today and places you on community supervision, if you violate the terms and conditions of your community supervision, then you can be brought back before the court for a hearing. And if the state proves to the court that you violated, the court could revoke your community supervision, could convict you of this offense, and could assess your punishment anywhere between 6 months and 2 years. You understand that? And you're asking the court to move forward with this plea. Understanding those things, Mr. Donahue, how do you plead to this offense? Are you pleading guilty because you are guilty? Well, I need a little more information then. You can be at the wrong place at the wrong time and still not be guilty of committing a criminal act. Are you guilty of committing theft of material containing aluminum, bronze, copper, or brass? And are you pleading guilty of your own free will, meaning no one's pressured you, forced you, or told you you had to plead guilty today? All right, the court will accept the defendant's plea of guilt. Mr. Stevens, any objection to states one? States one is admitted in evidence, and the court does take judicial notice of the defendant's judicial confession. Anything further from state? From the defense? All right, based on the court's review of the evidence, I do find there's enough evidence to convict the defendant of this offense. Court will follow the plea agreement in this case. The court does not convict Mr. Donahue. Rather, the court will defer a finding of guilt in this case. We'll place Mr. Donahue on 2 years community supervision. Court will assess a $2,500 fine, $290 court cost, $605 reimbursement fees. Mr. Donahue, you understand that by entering a plea today, you are waiving your right to appeal in this case? All right, Mr. Donahue, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted by the deputy. After that time, I want you to report to the Community Supervision Department. Say that again. I couldn't hear you.
I'm ready on my other cases.
Okay.
If you call it any order.
Okay. I'll do that. Misty Rice, CR 2133. Ms. Rice is set for pretrial today, Mr. Stevens.
No formal protocol.
All right, court will set Ms. Rice then for docket call. Remind me your schedule. I know you've got a vacation letter in. Are you available August 10th, 12th, or 24th?
Yes, sir. Could we do it on the 12th, Your Honor?
Yes,
Awesome.
that'd be perfect. Court will set Ms. Rice for docket call on August 12th. Ms. Rice, once you get the yellow copy, you sign and get the yellow copy, you'll be free to go. Leonard Williams, CR 2372. Mr. Williams is set for docket call today.
Yes, Your Honor. We're going to ask for another docket call. Mr. Williams and I had two different appointments in my office, and unfortunately, we weren't able to keep either one of them. He tells me he wants to hire an attorney. His family told him to hire an attorney. It's been a little bit delayed, Your Honor, because our home right now lost all his papers. So we're going to ask for another docket call in between now and then. I believe Mr. Williams will retain outside. Is that correct?
Who are you trying to hire and when do you think you can have them hired?
Yes.
Justin Willard, where's he out of? What town? Is it Justin Weiner? Weiner? And have you met with his office yet? Any objection from the state?
No.
right, so Mr. Williams, I note that this is our second docket call, so I'm gonna reset it at your request, but you're running out of time, so I'm gonna set it for August 12th. And if you're gonna hire Mr. Weiner, I expect Mr. Weiner to be hired into this case before the 12th, not showing up on the 12th and saying he's not hired me yet, or we're gonna be having a meeting, or he's trying to get up the money. I expect it to be done prior to that so that we can get going on your case. All right, once you sign the notice of setting and get the yellow copy, you'll be free to go. Is that all you have, Mr. Stevens? Or did you have a new appointment? Yes.
Mr. Rice, he is set at 1:30 at the jail this afternoon. I've got 4 MTR hearings set in Athens, and Mr. Rice is going to require, it's going to be a contested MTR hearing. And so I'm going to need a specific date from you. I was hoping to maybe reset it now. And I spoke with Ms. Hassel about it. She knows it. I was hoping to reset it now to avoid me having to get to the court like at 4 or 4:30.
So you have already negotiated and there's no agreement?
No, so we're not gonna be able to work it out. We'll do the hearing.
All right, let's see.
Are the contested hearings here in the courtroom?
Yes, we may be making the, yes, that is our plan to have them here in the courtroom.
I just need to know.
So we'll set that July 29th.
Judge, I'm going to be on vacation. I'll leave on Sunday the 25th and I don't return until Tuesday the 3rd of August.
What about August 26th? The bad thing about that is it's,
Oh, no, it's good. I was gonna say you're gonna shoot me, but no, I'm good on the 26th.
I mean, it sets him out pretty long.
It does. It'll give me more time to get with his mom and get her prepped up for the hearing.
It just costs us daily to keep him in there.
Yes, sir.
All right, let's set him for contested hearing on August 26th.
Well, I put it 9 o'clock on that one.
No, we'll do that at 1:30. Let's do that 1:30 since he's in jail. We're gonna try to make some changes on how we do things on that contested date.
It's a nightmare for us lawyers to go to jail. I've been going on the weekends because I can't get in during the day. Went Saturday morning, waited about 30 minutes. They came out and said, I'm sorry, but you can't come visit. You have to come Monday through Friday and check in at the administration office.
Have you tried calling to set an appointment? 'Cause know
No,
they're
I
doing
will
that.
next time.
Yeah.
But I mean, I've just been popping in like, because
Yeah.
Saturday's the best. Get in and out.
Yeah.
All right, so
All right, so Abram Rice at August 26th. We'll remember not to bring him up. And so he's aware of that?
he's going to be in a minute. I'm going to head there right now.
Okay.
Thank you, Judge.
You're welcome. Who else is ready? Nobody was ready earlier. Now you're all ready. So you ready too, Mr. Sanders? Mr. Ashmore spoke up first, so he gets it. He gets it. Kobe Heron, CR 18-263. Good morning, go ahead.
We're here this morning. We got a plea offer last night. We straightened it out and accepted it with the state. The offer is to extend probation 2 years concurrent with the pending DWI downstairs. All at some point going to be consolidated. So we're just asking the court for a reset to get that paperwork squared away. Come back before the court. I don't anticipate that'll take long.
What's your next setting on the misdemeanor downstairs?
It's actually Mr. Sawyer out of Smith County. So I need to call him before, but I understand from Judge Winters that he did follow, continue on his last setting so that this can be resolved up. So it's sometime this month, I want to say 23rd, 30th.
Mr. Herron, do you know when your next court date is downstairs? 23rd? August 23rd or July? All right, we'll set Mr. Herron then on August 24th. For plea. Yes, we'll see you back on the 24th. T. Anthony Smith. Mr. Smith is set for arraignment today.
He is, Judge, we're going to waive formal reading of the indictment. I have gone over it with him. He has confirmed that his name is spelled correctly both places in the indictment. He understands the nature of the allegations against him, the date on which it's alleged to have occurred, and has authorized me to enter a plea of not guilty and negotiate with the state of Texas on his behalf.
All right, court will enter Mr. Smith's plea of not guilty into the record. We'll set this for pretrial on August 24th at 9 a.m. Once you sign and get your yellow copy, you're free to go. Misty Backus. All right, and Mr. Ashmore, you were wanting to approach earlier. Do you need to approach or you just need to make an announcement?
Just make an announcement, Judge. I'm appointed on 2021-00026 her husband's case downstairs. That appointment came after my appointment in her case, but her indictment was returned later. So her file's been active in our office for some time. However, the activity's been on his case. That recently occurred within the last month. And I didn't have a chance to get a hold of her before this hearing. I've raised the issue of conflict. She needs a different attorney. She's a complaining witness in that matter.
Okay, that was gonna be my question. So she's the complaining witness against, what's his name?
Kobe,
Backus?
yes.
But you were appointed on this case first,
I think last summer, actually.
but his case was filed sooner.
It was, yeah. This case was just returned on a true bill in the last few days, I believe, weeks, and his was a month prior.
Okay. All right, the court will withdraw Mr. Ashmore as attorney for Ms. Backus. Ms. Backus, have a seat, and I'm gonna have my staff member get with you in a moment, and we'll appoint you a new attorney. Do you have anything this afternoon?
I do have things this afternoon, but I've also appointed on Jacob on Fredericks, who is here, may not be on your.
Mr. Frericks? CR 2163, Mr. Frericks, you are set today on the status to hire an attorney. Court has reviewed your request for court-appointed counsel, finds you to be indigent, has appointed the Honorable Casey Ashmore to represent you. Mr. Ashmore, have you had a chance to go over the indictment with Mr. Frericks?
I have, Judge. He's gone over the indictment with me. He has confirmed that his name is spelled correctly in it. He understands the nature of the allegations in the indictment, as well as the 2 enhancement paragraphs. He's authorized me to enter a plea of not guilty. Negotiate with the state.
All right, court will enter Mr. Frericks' plea of not guilty into the record. We'll set for pretrial on August 24th. Mr. Frericks, after you sign this notice of setting and get the yellow copy, I need you to report to pretrial release. You're going to be ordered to conditions of pretrial release that are going to be attached to your bond. You'll need to report, drug test, and pay towards your supervision fee and towards Mr. Ashmore's appointment. Okay.
Resets. Dispatches.
Yes, if you'll just keep that, or if you'll maybe give it to me and I'll give it to or lay it right there by the bailiff. There you go. That'd be perfect.
I'll see you at the jail.
Yes, sir. Yes, sir. Mr. Sanders, you ready?
Yes.
Who are you ready on?
Megan Bailey.
Megan Bailey, CR 2378. Set for docket call today.
Yes, the judge, who was asked to set it for plea, I think we have something on.
We're going to set it for plea and do a plea, or we think?
Well, there's one issue, basically having to do with the offer for probation, but there's concern that she's checking into regarding even though it's deferred, felony probation could affect our housing situation. And so she would want to have a little bit of time to check on that.
Let's not set it for plea then. Let's set it for final docket call. And then if she wants to enter a plea, then we can do it on that day. I don't like to set for plea and then us not have an agreement.
Okay.
Do you know when you're coming back in August?
No, wait, I was gonna say in July,
We do. We could do July 27th.
yes.
Okay. All right, Ms. Bailey, we're going to bring you back here in 2 weeks on July 27th. Once you sign the form and get the yellow copy, you're free to go. Charles Campbell, CR 2110.
We do have a true waiver.
Mr. Campbell, sir, if you'll raise your right hand. Mr. Campbell, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Campbell, are you wanting to waive your right to jury trial today? Do you understand that that's an absolute right guaranteed to you by the Constitution, and no one can take that right away from you? Do you understand that if you do waive your right to a jury trial, there's very limited circumstances in which that can be restored to you? And you understand that if it's not restored to you, then you're going to lose the right to confront the state's witnesses and their evidence in front of a jury? And have you made this decision of your own free will and accord? All right, court will approve the waiver of jury trial. Mr. Campbell, find that it has been joined by counsel for the defendant and counsel for the state. Go ahead, Mr. Sanders.
And Judge, if we could have a couple weeks, just set it for Friday, July 27th, that day will work.
Do the same thing? All right, Mr. Campbell, we'll set you for plea on July 27th at 9 a.m.
And Judge, Mr. Campbell is accepting an offer for business time, so we just ask that we can go ahead and start that process.
Okay, so we'll have you come at 1:30 on that day to the Van Dyke County Justice Center, okay? Haley Gandy. Ms. Gandy is set for pretrial.
And Judge, we don't have any pretrial issues, it's absolutely set for trial.
August 12th or 24th?
How about the 20?
24th?
I think I do already have one that day.
All right, Ms. Gandy, we'll bring you back on August 24th. That's a Tuesday. Travis Skinner. CR 2226 and 65. Update, are we still dealing with the toxicology for the victim's blood?
Yes, Your Honor, I emailed the lab, actually, you came with the Garland lab, they notified me that they had turned that over to the Austin lab, for toxicology screening. I emailed the Austin lab supervisor on July 1st. I did not receive a response, so I sent a follow-up email this morning asking them for, a timeline, projected timeline. We're still waiting on that. That's the last update that I have. I kind of, Mr. Sanders and I have talked about, because this has had a college judge. We talked about once those results come back in, if the results aren't such that it resolves the case, that we would ask the court for a special setting at that point and not focus on the rolling trial docket. It is one of our older cases. But we don't, either one of us feel comfortable announcing ready for trial, not knowing what the potential results of those would be.
All right, we're going to reset Mr. Skinner then for status on the toxicology for August 24th. Mr. Skinner, are you employed? Are you employed? You have a job? You take off to come into court? Okay, what I'm going to do is I'm not going to require you to appear on August 24th. All right, so you can, Mr. Sanders will be here and he'll get an update or give an update to the court on that. So I'm not going to have you appear on that date. However, on that date, I will assign a new date and you'll get notice of that through your attorney. Okay. So we'll wait and we'll see what happens on this. And you just still going to make sure that you're on conditions of pretrial release, right? All right. Make sure you're still reporting, checking in and doing those things. Okay. All right. You're free to go. Do you have any more, Mr. Sanders?
Yes, sir, I was waiting on Amethyst Wesley.
Okay. Ms. Wesley? This cause number CR 21198. Ms. Wesley, the court has received your request for court-appointed attorney, has reviewed that, finds you to be indigent, has appointed the Honorable Jeff Sanders to represent you. Mr. Sanders, have you had an opportunity to discuss the indictment with your client?
Yes, sure. We looked through the indictment. Her name is spelled correctly. We talked about the punishment range for a state jail felony. And if we would waive the reading of the indictment, the penalties of the range.
All right, court will enter Ms. Wesley's plea of not guilty into the record. We'll set her for pretrial hearings. On August 24th. That'll be at 9 a.m. Ms. Wesley, after you sign this notice and you get your yellow copy, I need you to report to pretrial release. They're gonna have additional paperwork for you. You're gonna be ordered to have conditions on your bond. You're gonna have to report, pay attorney fees, things of that nature, okay? So you'll report back here to these ladies and they'll give you more information.
So that's all I have.
Do you have anything this afternoon?
Yes, I was sitting here on that.
Justin Brown stuff for you? Okay. Are you ready, Mr. Couch?
Thanks, sir.
Joseph Couch, CR 2153. All right, Mr. Couch, set for pretrial today.
As indicated earlier, we have reviewed discovery in the case. I provided some additional information to the state today. Which Mr. Woodward's case actually, I think it was set on the final docket. It's going right on docket. So, what is it?
Are you available in 2 weeks on the 27th? Okay. All right, Mr. Couch, court's going to set you for docket call on July 27th at 9 a.m. After you sign your notice of setting and get your yellow copy, I need you to report to pretrial release because I show that you're delinquent. I show that you haven't made any payments on your pretrial release. Okay. I show you're about $120 behind. So as that grows, I grow more concerned on whether or not you should be on bond, okay?
I also have a bond paper, I think you back meeting with the probate. I'm not sure. He's actually back.
Does Mr. Couch have his notice so he can leave?
Basically,
Yeah, as soon as he's done, we'll call the next one. Yeah, come on back here. Is Christopher Nicely here? right, is that all you have, Mr. Knoll? Oh, yes, Mr. Byrd. Mr. Byrd, come on up. CR 21-166. So, Mr. Byrd, I had you on last week's docket, and I understand that you live out of state. Where do you live at? And I understand that you didn't have a ride to get down here. All right, you're going to just work really hard to make sure that you're here in court on time, because you weren't here last week, so I issued a warrant for your arrest. So there's a warrant pending for you right now. Most of the times I would just take you into custody and put you out in the jail and leave you there, and then I would reset your case. And when I was ready for it, I knew you'd be ready also. All right. So I'm going to withdraw the warrant in that case because you made an effort to be here on that date and you're here today. So, but I want you to understand that this cannot become a ritual occurrence. All right. So you miss court, there's a warrant's going to issue for your arrest every time. And it might always get withdrawn just because you show up a week later. You understand? All right. All right. The court has reviewed your request for court-appointed attorney and has appointed Honorable Kurt Knoll to represent you. Mr. Knoll, have you had a chance to, I think we were set for arraignment last week. Have you had a chance to go over the indictment with Mr. Byrd?
I have, Your Honor. Mr. Byrd and I reviewed the indictment. He understands what the charge is. His name is spelled correctly in the indictment. He is not guilty for purposes of arraignment.
All right, the court will enter Mr. Byrd's plea of not guilty into the record. We'll set for pre-trial. I would look to set him August 10th, 12th, or 24th. Do you know when you're going to be back or when that's better for you?
Well,
The 12th? All right, so Mr. Byrd, it's about a month. Okay, so you need to go ahead and start making arrangements to be back on August 12th, all right? Where do you live at? Jackson, Mississippi? How long does it take you to get here? 6 hours? Mr. Knoll, do you want me to set it later in the morning? Do you want me to set it like 11 a.m.?
that would be more convenient. Thank you.
Okay, so I'll set you at 11 o'clock. That's going to save you some time, but I know it's not. Okay, all right, well, I'll still set you at 11 a.m. just in case, all right? Yeah, that's fine. So, Mr. Byrd, as Mr. Knoll's filling out that notice of appearance, you've already checked in with pretrial release, right? Okay. So I'm signing this order withdrawing the warrant. It takes time for the processes to work to get your warrant withdrawn. So you need to be careful, right? So if you get stopped on the way home or have interaction with law enforcement, this warrant may still be showing on the system, all right? So Ms. Abraham, once you file that, will you get a copy of that to Mr. Byrd? That way you keep it with you, okay? So just understand it's still going to be active until it can make its channels back to the sheriff's office to have it withdrawn, okay? Is Marshall Flores here? Marshall Flores. Does not appear. Randy McElroy. Still no appearance. Bo Simmons. Bo Simmons. Still no appearance. Mr. Knoll, is that all you have today? Okay, all this morning. Mr. Crane, are you ready with Ms. Olds?
Yes, sir.
All right, if you'll go ahead and approach and bring me that paperwork. Good morning. You want to do Miss Olds? Miss Olds, I need Miss Olds. Is she gonna be a plea? Yeah, yeah. Yes. Yeah, I've called Miss Olds. Miss Olds is taking a plea today, correct?
Yes, sir.
Do you have the paperwork?
No, the prosecution does.
Judge, Mr. Woodwise reached out to multiple patients to confirm deals and do paperwork, but received no response back. From Mr. Crane or his office, we don't have the paperwork today because he never confirmed to us that the offer was being accepted.
So what is the offer that's going to be accepted? And what do you want the DA's office to prepare as far as plea paperwork?
The offer was made to us by the prosecutor before, was some kind of outpatient we have to be agreed to.
Okay, so I'll tell you what, Ms. Olds, just have a seat. Mr. Crane, you'll need to speak with the state. We need to get this nailed down. And Ms. Olds, have a seat. Mr. Gutierrez?
Thank you, sir.
CR 2168, State versus Adrian Gutierrez, set for pretrial. Do you have any contested pretrial motions?
Yes, we have one motion limiting about this criminal background. That's the one thing.
Okay, court's policy is I'm going to carry motions in limine to the time of trial. So do you have any contested motions such as motion to quash, motion to suppress, motion for discovery that you believe the state hasn't complied with?
We have nothing today, sir.
Okay. All right, then we'll set Mr. Gutierrez for a docket call, and this will be the time that I expect the state and the defense to be working together to try to determine if there's going to be a resolution in the case. So at docket call, I'm going to expect an announcement of either we're still working on it and here's why, or we're going to be accepting a plea agreement, or we're going to reject the plea agreement and we're going to request a bench trial or a jury trial.
Yes, sir.
So we'll set Mr. Gutierrez. Are you available on August 12th or 24th, Mr. Crane?
I might be, September would be a better month though. Awesome, sir.
Well, it's unfortunately, we're only going to go about 30 days out. So
That's what it said for this.
which one, 12th or 24th? 24th?
Yes, sir.
And if you have your calendar with you, I'll,
I have a pretty good recollection of what I'm going on.
all right, then we're going to set Mr. Gutierrez in for pretrial on August 20, I'm sorry, for docket call on August 24th at 9 a.m.
What time, sir?
9 a.m. And Mr. Gutierrez, I appreciate you being here at 9 since you're on bail. Most people don't pay attention when I say, if you're on bail, it's at 9. If you're in jail, it's at 1:30. Most don't pay attention and they show up at 1:30. So I do appreciate that.
Thank you, sir.
So Mr. Gutierrez, once you sign and get that yellow copy of the notice of setting, then you'll be free to go.
Okay, thank you.
There's one more thing I have, appointment at 11 o'clock for probation. Is there anybody give me a note or something?
Probation's right here.
Oh,
So they have representatives here, so they're gonna know.
okay.
And I will say, Mr. Gutierrez has been here since 9. He was here at 9.
Okay.
Mr. White, are you ready? Mr. LaPoma? All right, Mr. LaPoma, if you'll raise your right hand, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? And Mr. Crane, I'm going to ask you all to take your conversation elsewhere so that Mr. LaPoma can hear me.
I'm sorry.
It's okay. All right, Mr. LaPoma, are you a United States citizen? Do you read, write, and speak English? Did I swear you in? Did I ask you if you were going to tell the truth? I did. Okay. Sorry, I lost my train of thought. Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you? You feel like you've had enough time to discuss your case with him and have all your legal questions answered? Good. Is there anything about this paperwork that you've read and signed today that you do not understand? And Mr. White, do you believe Mr. Lapoma to be competent today?
I believe he's competent.
And you've explained to him his legal and constitutional rights?
I have to, I believe he understands.
Have you also discussed with him the advantages and disadvantages of a deferred adjudication plea?
Yes, I have, and I believe he understands that it's a situation where the state actually has a lot of room.
Mr. Lapoma, you're charged by indictment with a first-degree felony offense of manufacture, delivery of controlled substance and penalty group 1 between 4 grams and 200 grams. That is a first-degree felony that does carry a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division. What that means for you is if I approve this deferred adjudication plea agreement today and place you on community supervision, if you subsequently violate the terms and conditions that you're agreeing to today, the state could file a motion, they could bring you back before the court. We would have a hearing, you'd be waiving your right to a jury trial. And the state would put on its evidence. And if the court finds based on that evidence that you violate the terms and conditions of your community supervision, it means if you don't report, if you don't pay restitution or pay your fees, or you commit a new offense, or you drink alcohol, or you test positive for a substance, if you do violate any one of those, the court could revoke your community supervision, and then the court could assess your punishment, and it would have its discretion of anywhere between years all the way up to that maximum. So it's, as Mr. White has appropriately said, the state has a lot of rope here. That means there's a big sentence potentially hanging over your head. And that would be hanging over your head for 8 years. You understand those things. And you believe that you will intentionally comply, and you will be able to comply with all your conditions of probation. Have you ever been on probation before? Only for traffic? So this is going to be quite different. Okay. And I'm sure, Mr. White, have you discussed that with Mr. Lapoma? Okay.
I don't think there's anything that.
Okay. All right, Mr. Lapoma, then understanding the range of punishment in the plea agreement, how do you plead to that offense? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? All right, court will accept the defendant's plea of guilt. Mr. White, any objection to states 1?
No.
States 1 is admitted into evidence, and the court takes judicial notice of Mr. Lapoma's judicial confession. Anything further from the state, from the defense?
You are entering into probation properly with medications. There is possibility.
Thank you, Mr. White. When your medications change, you'll tender that to your community supervision officer. You'll let them know, and they'll keep it in their records over there. And the probation community supervision officer reports back and forth to the court. So that's how you get that information. I'll take just a moment. I'm going to look through your case here. All right, based on the court's review of the evidence, I do find there is enough evidence to convict Mr. Lapoma of this offense. However, the court will follow the recommendation of the state and the plea agreement. Court hereby defers the finding of guilt, places Mr. Lapoma on 8 years community supervision, orders him to pay a fine of $3,500, $180 restitution, $290 court costs, and $35 reimbursement fee. The court also takes into consideration unlawful carrying of a weapon and possession of marijuana as contained in the judgment. All right, Mr. Lapoma, you've got an opportunity here to sidestep a very serious crime. Okay, first degree felony is as high as they get, other than capital murder. Okay, so my recommendation and advice to you is to be overly compliant with everything your community supervision officer says. Don't be a problem. Have a good attitude. Do what they tell you to do, even when you don't like it. Because if you decide that you're going to do what you want to do, you're going to end up back in here. And whenever it comes time for me to determine if you do violate your conditions of community supervision, when you come back in front of me, I'm going to look back. If you show up in 7 years and 11 months, and in that last month you violate, I'm going to come back. I'm going to look. If I'm here, I'm going to go back. I'm going to look 7 years ago about what got you on probation. Okay? And that's serious to me. And I hope it's serious to you. Okay? So Mr. Lapoma, you're hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the deputy, and then I want you to report to probation. Thank you, Mr. White.
Thank you, Your Honor. That's all I have.
Do you have anything this afternoon?
No.
Have a good day, sir. Did you give Ms. Backus that new order by chance? You did, so she has it. So she has Jonathan's contact information. Okay. Do you know when Jonathan's coming back by chance? You know, I was complaining about this the other day. I wish they were like smart bench. I could just look on a given day, it would tell me every return that's there. Totally agree. Better than here. I said, I'm looking back to my text messages. I sent him for 7:15 for a ring on somebody, but that doesn't mean he's gonna be here. He's here on August 10th. Okay, I'll just set her there. Ms. Backus. All right, Ms. Backus, so the court's going to appoint Jonathan Manning, another licensed attorney. Mr. Manning's office is adjacent to the Van Zandt County Justice Center out here. He may not, he won't become aware of this appointment probably for a day or so. So I believe that Ms. Taperham has provided you with a document that has his phone number and address on there. So if you call him, yes, correct. If you call him, he may not be aware of who you are, but you can let him know that he's been appointed to your case and that he'll be receiving that order from the court soon. What I'm going to do is I'm going to reset you to come back on August 10th with Mr. Manning. Okay. So we're going to have you sign this notice of appearance right here. And then once you get that, you'll be free to go. All right, and you're with Mr. Lapoma, correct? Okay, all right, I thought so. All right, and you are with Mr. Crane. Okay. Back on the record, CR 2302, Ashley Autumn Olds. Announcement.
Yes, Judge, we have all the terms nailed down. I have to put those on the record. The court would like that. We would ask for a very short reset. I believe the court's next available date is the 27th of July. We believe that's sufficient time to get all the paperwork done. Ms. Olds, as a condition for probation, is going to do both intensive supervision and non-compulsion drug treatment. So we're asking for the reset for her to get some literature on that, start that process. And this is will be for probation with drug treatment as a condition.
Do you believe 2 weeks is enough time?
I believe so, Judge.
I'm sorry.
If we reset for 2 weeks, do you believe that's enough time for Ms. Olds?
Thank you.
All right, and I don't need to know the terms as long as y'all got them nailed down and we'll be ready next time. All right, so Ms. Olds, we'll see you back on July 27th. We'll do that at 9 a.m. All right.
Very good.
Can you call a couple names for me? There's only 4. And they are circled for you. There's 5 downstairs. Any response to the names called in the hallway?
No response, Your Honor.
All right, the court has had Marshall Flores, Randy McElroy, Bo Simmons, and Christopher Nicely's name called loudly, distinctly 3 times in the courthouse. There's been no response. The court has called their name multiple times in the courtroom with no response. Court hereby issues judgment Niceeyes and alias Capias in each case. Court will stand in recess until 1:30.
Audrey Thompson on page 2. Did she feel
Oh, that's a good point. I did have this one on here.
but
Let me check, because you're right. And it says applying for court-appointed attorney.
Sir?
Did Audrey Thompson come and see you about court-appointed attorney? Yes, Deputy, will you call the name Audrey Thompson in the courthouse?
And tell her to come this afternoon, or?
Ask her, where did she go? All right, and Deputy, you had called the name Audrey Thompson loudly, distinctly 3 times in the courthouse?
Yes, sir.
All right, let the record reflect that the court had not previously called Audrey Thompson's name. Understands that Ms. Thompson was present in the courtroom. Her case was not called before the court. She had spoken with court staff about applying for court-appointed attorney. And then upon consultation with court staff, had indicated that she was going to retain her own attorney, and she did not return to the courtroom. And her name has been called loudly distinctly 3 times in the courthouse with no response. So court staff is speaking with, going to call Ms. Thompson at the number provided. If there is no response, and if she does not appear today, then the court's going to issue a judgment not assigned alias capias. I will take that under advisement until 3:30 today.